Hey, Mr. Johnson, you go first.
Good morning, Your Honor. May it please the court. My name is John Johnson, and I represent the appellants uh, Gisela Jaramillo et al. And we are asking this court to reverse the trial court's order that dismissed the plaintiff's or the appellant's second amended complaint with prejudice. Now, this court reviews a granting of a motion to dismiss um, by a de novo review and based on an abuse of discretion standard. In the brief, I argued that the trial court abused its discretion when it dismissed the second amended complaint for several reasons. First of all the counts of the complaint were pled with legal sufficiency and included valid causes of action. Secondly, it was not necessary at this time in the litigation to include all, quote, indispensable parties. Third, that the appellants were not limited to charging lien litigation as the sole basis for relief of the claims in the complaint. Additionally, the complaint included novel claims that cannot be foreclosed upon merely because limited or no case law exists to support the appellant's claim. And additionally, that the trial court improperly chose to dictate how the appellants must litigate their case merely for the convenience of making the case more manageable. But what I want to focus on in this brief time I have before you, oh, by the way, I would like to reserve 5 minutes for rebuttal, please. Is that the trial court erred as a matter of law in considering things outside the four corners of the record when it dismissed the appellant's complaint with prejudice. And the trial court's ruling on the motion to dismiss is relatively short. It's in the record at 860 to 862, and it is very telling. The trial court says, I'm dismissing the case with prejudice. She starts out by mentioning how Mr. Sachs, I didn't go through the facts of the case. I'm sure you're very familiar with the facts of the case. So Mr. Sachs was the only attorney under Mr. Jaramillo who died suddenly and unexpectedly, and there was no inventory attorney to maintain the firm. So what happened was she mentioned about Mr. Sachs contacting the Florida bar and the Florida bar letter. And there's absolutely nothing in the record that would support that allegation. So the trial court considered things outside the record in order to make its determination in granting the motion to dismiss the appeal. And that's simply error as a matter of law. So what I also want to emphasize is this case is one of first impression. So one of the things the trial judge did in its brief granting of the appellant's second amended complaint is she talked about distinguishing Winters v. McCullen. And that is important because part of the reason one could consider that this dismissal with prejudice should stand is because there's absolutely no viable way that the appellant can state a cause and action for which relief can be granted. But the Winters v. Mulholland case is very similar factually to the facts at bar. The problem, well, one of the additional layers in the case is that, of course, Mr. McMullen's firm was still in existence and he was still alive. And of course, in the current case, Mr. Jaramillo died without an inventory attorney. So we have that dimension there. But one of the issues that we pled in the second amended complaint was this possibility that there's actions against Mr. Sachs and Mr. Castle about their actions during that period of time that Mr. Sachs may or may not have been with two law firms, with the Castle law firm or with his own law firm, and still a member of the Jaramillo law firm, and that there is accusations that there may be issues involved with that. And that's why, in addition to the charging lien litigation allegations in the second amended complaint, we also look at unjust enrichment, conversion, breach of fiduciary duty, fraud, counts under the Florida Deceptive and Unfair Trade Practices Act, and civil conspiracy. All
Mr.
these.
Johnson, let me ask one question, because you raised this issue of contact with the Florida bar, and let's set that aside for a moment. The complaint alleged that the attorney let the clients know basically what happened. You have a choice. You can take your files, you can hire someone else, you can go with me. And clients responded. Most of them apparently responded one way or the other. So that sounds to me like a classic situation, not of, and I don't want you to think that I'm trying to prejudge the ultimate issues in this case. That might someday come out or might not, but a charging lien is intended to protect a law firm for the work it has done. It is not intended to prevent a client from getting the case completed and choosing the lawyer to complete the case. So I'm struggling, and maybe the trial judge was struggling with this as well, is you have individual clients who get the letter, they make whatever decision they make. And so each case is going to depend, or each claim is going to depend on what the client did and why they did it, and then what happened with the case. And that's typically what a charging lien is for. And so it seemed that the concern the trial court had is, how are you possibly turning this into one compiled lawsuit with 100 or so clients?
So certainly the trial judge was challenged on how logistically this was going to occur. And I bring the issues as to the complaint addressing the actions of Mr. Sachs and Mr. Castle, only to say that there, in addition to the charging lien, there may be other causes of action that Ms. Jaramillo can seek toward their actions as it relate to what they did, and their actions are detailed in the record about
But what you just said begs the question. Before a lawsuit is filed, there is supposed to be a factual determination as to what claims may or may not exist, as opposed to what I think the trial court felt like a shotgun pleading, coming up with theories that may be non-existent based on the facts of what occurred. The unfortunate demise of the attorney. You have one lawyer left who is trying to figure out what to do with these cases. And so I'm again concerned as to, was this lawsuit prematurely filed? Because what you just said is, maybe there would be facts that would support a claim. And I understand we're not at an evidentiary basis, but it seems like that's what the court is looking at, is how are you getting here?
Well, and I don't think the court gave the appellants the correct amount of time in which to build their case. So let's look at what happened. The appellants filed a complaint. There was a motion to dismiss filed by the police. The appellants filed an amended complaint without the first motion to dismiss going to a hearing. They did it pursuant to Rule 1.190, and so they filed an amended complaint. The police filed a second motion to dismiss that went to hearing. Now, after the hearing on the motion to dismiss, the amended complaint, the trial court granted the motion to dismiss in part and denied the motion to dismiss in part, which leads to the hearing on the appellee's motion to dismiss the second amended complaint, which is the granting. That's the issue on appeal here. So if you just look at how this case has progressed, this isn't a case where this is the first time that the trial court has dismissed the entire case in total. So it is not like this court that the appellants are abusing the process or abusing the amendment process, but certainly the appellants are in an awkward position because it's the personal representative of the deceased attorney that is proceeding in an effort to move forward on this litigation based on what she feels is there's been a wrong that's been in effect. And certainly there were discovery issues throughout this litigation that the appellants had challenges moving forward. So we believe the motion to the order granting the dismissal with prejudice is certainly premature. A first motion, granting of a motion to dismiss with leave to amend is what we believe is the appropriate remedy on this case, but there was nothing in this record that would indicate that there is no possible way that the appellants can draft a complaint that would meet the standard of there being a cause of action that the court can hear. And the reason for this is the case is a novel case. There is no case on point with these set of facts. And so the appellants deserve an opportunity to get this litigation before the court. And I also have to say that the appellants are concerned that in an effort to expeditiously move the judge's docket forward, that she was attempting to say that the Moniz v. Smith case, say charging liens should be done in a certain way. And that is the preferred way, but it's not the exclusive way. There is no case law that says that the charging lien litigation has to be done that way. And so there may be another remedy. And we have been foreclosed on pursuing that because of what we believe is the judge's premature granting of a motion to dismiss with prejudice, and also based on her reliance on something that is outside the four corners of the document. I also wanted to bring up the indispensable party issue that was raised by the appellees, both in their motion to dismiss the amended complaint and then the motion to dismiss the second amended complaint. I think a quote from the US Supreme Court is very telling in this case. And this is the Patterson case that I cited in my brief. It says, to say that a court must dismiss in the absence of an indispensable party and that it cannot proceed with him puts the matter in the wrong way around. A court does not know whether a particular person is indispensable until it has examined the situation to determine whether it can proceed without him. Going to your point, Judge Silverman, yes, as a judge looking at 100 different cases, you're wondering how you can case manage this. But this is not the time to do it. The option would be perhaps a motion for summary judgment down the line. I mean, the summary judgment rule is changed, and I think that's a better way to proceed as opposed to foreclosing any opportunity for the appellants to get relief based on their numerous causes of action raised in their pleading.
And Mr. Johnson, you're closing in on your 5 minutes, so proceed as you wish.
I will stop right here and reserve the rest of my time. Thank you.
Okay, Mr. Coe?
Good morning, Your Honors. May it please the court. My name is Brian Koch, and I represent the appellees, Castle Law Group, Sachs Law Group, and attorneys Matthew Castle and John Sachs. And we are here today to ask the court to affirm the trial court's order that dismissed the appellant's second amended complaint against the appellees with prejudice. The trial court's decision was not an abuse of discretion. Rather, it was the correct result after the appellants failed over the course of 3 separate pleadings to state a cognizable cause of action, and any further attempted amendment would have been futile. Now, just to start out, the appellant's brief correctly states that this case is, quote, very unique. They said it, I think, approximately 5 times in their brief. That's because this case is unprecedented. Notwithstanding the fact that there have been hundreds of thousands of lawyers in the state of Florida, tens of thousands or more that have passed away, this is the first time that I have seen, this is the first time in the cases I've looked at where you had an estate trying to essentially proceed and make claims against successor counsel that was chosen by the clients in order to proceed, where they're trying to bring claims against successor counsel rather than utilize any type of form that you would normally see, which would be charging liens, or going after the only party that they would have been in privity to, which would have been those clients based on the contingency fee agreements that the firms had with those clients. There was no cognizable claim to raise in this case. They admitted in their briefing that they were attempting to throw whatever they could against the wall and to see what sticks. Their initial brief on page 10 complains that they had difficulty drafting allegations, but that's in part due to the fact that they were making up new claims against successor counsel wholly unsupported in law. Your Honors, I would like to just address one fundamental issue out of the gate, which is that the brief that they filed identifies no errors whatsoever as it relates to demonstrating how any of their causes of action that they raised were somehow legally sufficient. All they do is include a conclusory statement. I think it's pages 30 to 37 of their brief. It's a very formulaic, this is the cause, this is the elements, we sufficiently did this. There is no explanation. There is no tying of any facts to any elements to actually demonstrate that there was any error. And it's not for Your Honors to have to determine that. It shouldn't be for us to have to determine that. They fundamentally have an obligation to have come to this court and to actually explain what the error was as to each of these particular counts. And the case law in this district, as well as others, essentially says that you've abandoned or you've waived your ability to make that type of claim when you don't brief it at all. And in this particular case, every single statement that they made as it related to every single count was conclusory. And you can't use oral argument, or you can't just say, oh, my reply brief, I want to go back and say what I said down at the lower court. That's not what you're allowed to do. They were supposed to identify those errors. They never did. I also want to address some overarching fundamentals as it relates to these types of claims. First of all, the Scherer case from 2021 from the second district here, cases belong to the client. They don't belong to the law firm. This was the bar rule, I think it's 4-5.8. It was passed in 2005 to really codify and to make sure that that was the case. Because up until 2005, lawyers could just take the files and go run with them to their new firm. There was no check and balances as it related to that. And it's very clear that the cases belong to the clients, not to the law firm. Second, there's no non-competes in the legal industry. This entire case essentially stems to, you stole my clients. My clients, these firms, I wanted to get whatever attorney's fees that might be generated from these clients. That's fundamentally what this case was entirely about. But there's no non-competes in the legal industry. Clients have a right to choose their counsel. And at all material times, I think everyone here can agree that the priority interest is making sure that the client's rights are protected. Now, once Mr. Jaramillo passed away, and a couple of days later, when Mr. Sachs decided to leave the firm, and that he at that point in time, there is no living or licensed attorney on behalf of the Jaramillo firms. As a matter of law, the Jaramillo firms cannot render legal services. They cannot do anything further. And this all stems in part, the irony here is that this is a case that involved a lawyer who had no successor planning, who actually didn't have a will, and had no real plans. And that's what created this situation. But the Shearer case also talked about associate attorneys. And in that case, it actually talked about a shareholder. And that when a shareholder left a firm, that shareholder no longer had any right, or I'm sorry, any obligations to the prior firm. Now, Mr. Sachs wasn't a shareholder. He was an associate attorney. They have pled that Jerry Jaramillo owned 100% of two of the firms. And I believe there was a split of ownership interest as it related to the firm with Gerald Spurgeon, who had also unfortunately passed away in the last few years as well. But with no attorney there to represent the Jaramillo firms at the time that the lawyer leaving letter had to go out, as a matter of law, that firm couldn't continue to take the representation. They had to cease the rendition of legal services. 4-8.6 of the bar rules specifically discusses the fact that a law firm must cease to render legal services if there's no members at any point in time that are still practicing. And they've made an argument, or they've made a suggestion as it relates to an inventory attorney. What is an inventory attorney for? Specifically to protect the clients. That inventory attorney is not there to say, okay, I'm going to have these clients engage me and I'm going to continue to work or act. It's to make sure that the clients are protected. And there is no allegation whatsoever of any clients with any harm. And when Mr. Jaramillo passed away, those clients shouldn't be punished because Mr. Jaramillo didn't have a succession plan with respect to his firm. Now, what they're trying to do is they've lumped approximately 100 cases together, and they want to assume 100 cases in a single proceeding. When he made statements as to the dismissal based on the April 2024 hearing, Judge Thomas specifically talked in the first 40 minutes of that hearing about the fundamental problems that this case had. That it was just fundamentally, there were issue after issue after issue. She didn't reach the merits with some of the other arguments because at the end of the day, she was granting what we had requested, which was a complete dismissal, and said, look, I want you guys to at least figure this out, fix it. You've seen some of my concerns. Months and months go by. They don't fix any of those concerns. Now, a couple of notes with respect to this. The main argument that I think they're now leading with is that somehow there was something that was considered outside the four corners of the complaint. First of all, the order dismissing the complaint makes no reference to anything outside the four corners of the complaint, except for a slight reference to the fact that there were other charging lien matters. And this is important to note that there was a distinction between the first motion to dismiss hearing and the second motion to dismiss hearing. On the same day that the first motion to dismiss was ruled upon, where she granted it and said they had leave to amend, there was also a stipulated order for the court to be able to take judicial notice of the other charging lien matters. And they filed approximately about 8 to 10 charging lien matters relating to the same cases, the same 100 cases or so. They had already filed charging lien matters with respect to some of those other cases. And the Bayview case from the second DCA specifically says that where parties have stipulated, and that's a stipulated order, where the parties have stipulated that the court can take judicial notice, then the court would be allowed to do that. Now, the Judge Thomas didn't go through every charging lien matter to take a look. This is what happened here or what happened there. All that she essentially did was to note that there were charging lien matters, which meant that the plaintiffs in this particular case, or the appellants, had an adequate remedy at law as it related to being able to pursue the case against those former clients. And they make this reference to the Moans case. They are correct. Moans said that this is not the preferred method. It doesn't say it's the exclusive. The other method that is used when you're going after clients for attorney's fees that you believe the clients owe, if it's not a charging lien case, you're allowed to sue them for breach of contract with respect to the contingency fee agreement that that firm had with those particular clients. That's not foreclosed by anything that's happened here. What the case says, and what every single case that has ever looked at this has said, is that when you are seeking attorney's fees, and in a contingency matter, the client whose case that involved needs to be part of that process. And that's why those clients are essentially indispensable. Every cause of action that they asserted in this case had fundamental and fatal deficiencies that warranted the dismissal. I could go through each one, but we outline them in detail in our brief with respect to that. We also outline them in detail in the motion to dismiss. And in this particular case, they didn't even address the elements as it related to those particular claims and why each and every one of them was deficient. So your honors, fundamentally, the cases belong to the client. Their attempts to try to sue successor counsel here are unwarranted. This unprecedented as far as this case went. And outside of any questions that the court may have, we would ask the court to affirm the dismissal with prejudice. This is the baseball rules, 3 strikes and you're out. They were warned of these things with respect to the original motion to dismiss and what the deficiencies were. They were essentially warned again with respect to the motion to dismiss the amended complaint. And then, of course, they never bothered to change that. Fundamentally, there was a question that had been asked about, he tried to raise the issue of saying, well, the case wasn't far enough along. We wanted to have discovery. By the time this case was heard with the motion to dismiss, it had already been pending for almost a year. They conceded that they had the firm files. They don't make any allegations that they had suffered any damages with respect to any of that. They had everything that they needed. And so, your honors, we would ask that this court affirm the dismissal was correct. This case is unprecedented. And just because something is novel, novel means fictional. It means it could be made up. But there's no case that has ever allowed a suit to go forward against successor counsel. Finally, one other point. They mentioned the Winters case. The only claim that was actually heard by the appellate court with respect to Winters that was actually discussed was a claim for civil theft. They actually reversed with respect to that one claim that was there. And so that case is not on point. Again, that case also involved allegations where the lawyers who left that firm, they went into the computer system, they altered data. They essentially told all the clients that the attorney was retiring, and so they had to go with them. They made false allegations with respect to that. None of that type of allegations are alleged here. This case should really have been dismissed. It was properly dismissed. We would ask this court to affirm.
Okay, thank you much. Mr. Johnson, 5 minutes for rebuttal.
2 to 3 items. First of all, the appellees in their briefing today talk about there is no error as a matter of law when the judge talks about Mr. Sachs consulting the Florida bar. But if there is a difference between a judge's oral pronouncement and their written order, the oral pronouncement is what is primary. And so you don't erase the error as a matter of law because the order on the motion to dismiss the second amended complaint with prejudice doesn't include the fact that the court relied on something outside the 4 corners of the document. Secondly, part of the appellant's claim has to do with the actions of Mr. Sachs, not only as it relates to how he contacted the firm's clients, but also what happened to the trust account, because there's allegations that Mr. Sachs and or Mr. Castle were spending down the trust accounts. And in fact, if what the appellees say is correct, that the law firm doesn't exist anymore, then why is Mr. Sachs using the trust accounts to manage the clients before they are transferred to the other person? So we're asking this court to reverse the trial court's order, which dismissed the appellant's second amended complaint with prejudice, and to remand for proceedings below because the court abused its discretion, and even more importantly, the court erred as a matter of law when considering things outside the record by her own oral pronouncement, and that is an error as a matter of law, and we're asked this court to reverse the trial court's order. Thank you for your time. Appreciate it.
Thank you both very much. In order to leave our virtual courtroom, you need to click the leave button in the lower right-hand corner of your Zoom screen.
Thank you very much, Your Honors.
Have a good day. And with that, that was our last case on the docket, so we are adjourned.